Friends, we're watching the fled the scene murder case in Kentucky. We're in the defense case right now with their first witness, who's an accident reconstructionist. He told the jury it's his opinion that Bradley Caraway was the passenger, not the driver, on that fateful night.
Go ahead, sir. Right there, gotcha. What you're looking at is a tire mark. This would be the shoulder of the roadway, travel portion of the roadway. The earth embankment, for purposes of this photograph, would be to the left where the collision occurs. We're starting at the beginning of the dynamic of the crash. The vehicle, for whatever reason, departs on the right shoulder of the roadway, attempts to overcorrect. That's what we're referring to as the operator's trying to overcorrect. Can you move forward one, please? Kind of a back view, if you will, but you see the mark, and then you see the 1, 2, 3, 4 tire marks. That indicates that the vehicle's now sideways. When you start seeing 4 tire marks, the vehicle's now sideways, sliding in that direction, out of control, but in what we refer to as a yaw. The 2 black marks that you see there are relatively parallel to the shoulder of the roadway, were the marks that were originally believed to be as a result of this collision. I know the next day they went out and did another total station diagram, realized that wasn't related to this collision, at least from this particular vehicle. Was it part of the collision? Don't know, but wasn't, at least from this particular vehicle. We know that from the tire marks sliding over top of those 2 parallel black marks, which indicates the 2 parallel black marks were there first. Then the vehicle goes off the roadway, strikes first with the right front portion of the car. Not the front of the car, with the right front portion of the car. Occupants inside vehicles travel opposite and parallel to that direction of force. Wherever the force comes, we travel opposite and parallel. For example, if I'm driving down the road and I hit a pole, I'm going to continue to go forward, hit the dashboard, whatever the case may be. In this particular case, because it hits this direction, this would be our principal direction of force. Both occupants move in that direction, so they will travel forward to the right. When they do that, contact's going to be made on the inside of the vehicle. When the vehicle hits the embankment, it begins to flip, begins to roll. Now, we know from the LMPD total station diagram where they marked all the evidence, what they do out there. I agree that these are the tire marks that it left the roadway. I agree with all the dimensions that they have taken, impact marks in the embankment, or in the dirt. The problem with that is it was never defined as what part of the vehicle is leaving what part of mark. Was it the side? Was it the trunk? Was it the front? It just shows different marks in the earth embankment. That distance is about 500 plus feet from the time that they leave the roadway to the time they come to final rest. Miss Moorman is found underneath the car at its final rest, which means that she has traveled some 500 plus feet to get to the position where she's under the car at final rest, unfortunately. The vehicle is facing relatively parallel to the roadway, but it's on its passenger side, kind of facing down, if you will, in this attitude with these windows down. As the vehicle tumbles, it's my belief that Mr. Caraway is in the right front passenger seat. As the vehicle begins to overturn, the right front window breaks out. There's glass throughout the tumbling on down to the final rest. The windshield has been, we use the word ripped, teared, but it falls back into the passenger compartment. So it's my opinion that no one goes out the front windshield. Because they go to the right, both of them are going to move to the right. The EDR data, the black box data, will show that the driver's side seat belt, the pretensioner, which is a portion of the seat belt that causes the seat belt to lock in position, we'll use the term fired. It activated. And that happens in about 60 milliseconds, very fast. However, because it wasn't a frontal impact, it's my opinion that the seat belt did not cinch, did not pull the occupant back into the driver's seat. When I examine the vehicle, you can still freewheel.
Judge, can we approach?
You may. All right, and so we've got objection, we've got another sidebar here. And we're slightly behind on the video because we wanted to hear all the important things. The court has just taken a short recess, so just want full transparency here. As soon as they're back in session, we're going to go back in live. But for now, let me bring back in my guest. He is a criminal defense attorney in Louisiana. He also served as a prosecutor. Mr. Franz Borghardt is on the show with me today. Franz, I've got some information that one of our Court TV producers just passed along to me. And this is coming from TV station WAVE. They reported that this expert witness, Henry Cease, had his own DUI some years ago. He was working as a state trooper in Kentucky at the time in 2010. Apparently, according to WAVE, he blew a .133, was charged and pleaded, and had his driver's license suspended for 30 days and went on to continue with his career. And most likely, I'm thinking if Kentucky laws or anything like the laws in the Commonwealth where I practice, because it's a first-time offense, could certainly be titled to an expungement, and penalties are far less stiff than they are for a guy like Bradley Caraway, who's got multiple DUIs. But our Court TV team found that interesting, kind of ironic here that we've got, you know, a DUI case at issue, and this expert witness had some firsthand experience. Your reaction to that, Franz?
Well, theoretically, it really has nothing to do with his expertise, right?
Right.
We both know doesn't really change anything.
Exactly.
However, jurors are funny little creatures, and it may be that if it comes out, if there are questions asked about it, depending on how he answers those questions, that may affect how they view him. But, you know, here's the thing. DWIs, and I don't mean this lightly, Julie, DWIs are the most common crime that average citizens commit,
yes,
right?
You're right.
If there's only done on the first one, right? It's just one. So it's different when you have multiple. Now, here's the thing. Did the defense know this when they hired this guy? Did they know this and they said, you know what, he's such a great expert, we don't care, we want to use him anyway? If they didn't note that he was, in fact, previously convicted of a DWI, that could be problematic because, I mean, are you going to hire somebody that has that wart on his face, which, again, has nothing to do with his expertise, but is an issue? So, you know, it is interesting. It is ironic. But at the end of the day, he's doing a great job. You know, I was sitting there thinking that objection that they were making just now, I was thinking my objection would be probably, Judge, he's really good, and I object to that. You know, I mean, it's like.
I thought this thing, Franz, like they're just disrupting this to disrupt it. You know what I mean? Yeah, no, this is not going well for them. We've all done it. I fully admit I have jumped up and just lodged an objection just to disrupt the flow of something that was really going strong, you know, and it's been done to me. Good trial lawyers, we know when to jump in and we know when to stay quiet.